Sharing, you are audible. Yes, sharing, you are audible.
Right. Good evening, everybody. We are starting the lecture series in the drafting paper for the Advocates and Record examination. As you're aware, this examination is held twice a year. You have several papers, and drafting constitutes possibly the most important aspect of an Advocates and Record training, presentation, and lays the foundations for his career. Let me give you an introduction about our system so that you will get a clearer perspective as to how you work things out. The Supreme Court, as you all know, is a court of record under Article 129. A court of record means an institution or a court which retains its records for time immemorial, and the records are available for all purposes, both precedents, history, as also for gaining knowledge for the future generations as to what the court has been, how it has functioned, what have been the judgments, what have been the proceedings, what have been the presentations which have come to court. If you keep this basic frame in mind that you are a court of record with whom you are working as an advocate on record, and simultaneously the fact that the Supreme Court is a court unique to the many superior courts in the world because it exercises myriad jurisdictions. You have a constitutional jurisdiction, you have an appellate jurisdiction, you have a contempt jurisdiction or the inherent jurisdiction, you have a plenary jurisdiction, and you have an original jurisdiction. Let me first, with the permission of my friend Bharat, give you an introduction to the jurisdictions which take place. Constitutional jurisdictions are fourfold. You have the writ jurisdiction, which all of us invoke, either for individual relief or in the public interest. You have reference jurisdictions. References come both from the president when he seeks the advice of the court. A reference comes from the UPSC for the purpose of initiating proceedings against a member. You have a reference jurisdiction under the Income Tax Act, where references come for the purposes of answering questions on tax. Then you have a very salient jurisdiction which deals with disputes between the states. That is the jurisdiction of the suits. If you keep these 4 or 5 jurisdictions before you, you will see that the original jurisdiction of the court is very wide. It has another one which comes under statutory provisions, transfer of cases from one state to another, from one place to another, both for the civil and criminal jurisdictions, 406 CRPC, 2324 CPC, and Article 139A. Then you move into the normal jurisdictions in which we dabble. You have Article 136, the plenary jurisdiction, which deals with special leave petitions. If you want me, I'll go slow, but I will dilate on all this later. This is just an introductory to all of you. 136 is the plenary jurisdiction. Any order of any court can be challenged directly in the Supreme Court. It is not necessary that you have to come via the High Court, but any order at any stage, including a labor court or a matrimonial court, can come and challenge here. So this is the widest jurisdiction the court enjoys. Plenary, absolute. There is no fetters on its jurisdiction. Then you come into the domain of appeals. Appeals come under Article 132, 133, 134A. Apart from that, you have the appeals which come in as ancillary powers of the court, which include appeals from statutes. Statutes provide for appeals. You will find appeals coming in from all sorts of places. TDs Acts, orders, Monopolies Commission, Competition Commission. So those become the appellate jurisdictions of the court, where you come up straight in appeal to the orders and you challenge them in the Supreme Court. So the gamut of jurisdictions is indeed very wide. In addition to that, you have the inherent powers of the court. You have the contempt powers, as I mentioned earlier. You have a power of review. After the judgment in Ashok Hura of 2002, you have a extraordinary jurisdiction, which is called the curative powers. So if you look at the overall functioning of the Supreme Court, it is very unique compared to other courts. The function of an advocate in record is not only to participate in the process of drafting, but it is also to present views through its association for the changing, alteration, and amendment of the system. Along with the plenary powers of the court, you have a rule-making power of the court, which comes under Article 145. The rules of the court are meant to regulate proceedings in the Supreme Court. These rules, in one sense, come under the practice and procedure paper, but they also play a role in drafting. And I will correlate the Supreme Court rules with the plenary jurisdictions and the drafting requirements of an advocate and record to be kept in mind when presenting a draft in the Supreme Court. Keep this in the background, and now let us come to what is drafting. The purpose of a draft, which an advocate prepares, is to present a statement of facts as briefly as possible to any court. Under the Civil Procedure Code, you have drafting which is prescribed. Order 7, Order 8, plaints and written statements. You have provisions for review. You have provisions for first appeals. Under the Civil Procedure Code, you have a gamut of appeals, a gamut of proceedings which come. In the Supreme Court, we have a similar situation, but I will dilate on that in a few minutes. But now when you pick up a draft, how do you approach it? How do you present your client's case? Do you present it on law? Do you present it on facts? Do you present it in a combination of both? How do you go about being precise in your statement of facts so that the draft gives a clear exposition of what your client seeks, whether on the original side or whether on the appellate side? So when you are to settle down to drafting a petition, what you must do is, on a piece of paper, or if you're very brilliant, like most advocates think they are, garner your facts, put them in sequence. By putting a statement of fact before you, you make a skeleton of your draft of what you want to say. Once you have a skeleton of your draft, into that, you will weave your facts. That is, you will put your facts in a narrative. When you put your facts in a particular narrative, you will then look at the questions which arise. It can be a transfer of property matter. It can be a constitutional issue. It can be an appeal. It can be a transfer petition. It can be an inherent invocation of Article 32 jurisdictions of the court. It can be an original suit. So whenever you draft any pleading, the pleading is the fundamental document on which the court will now proceed. Now, there are various ways of looking at a draft. Some of us have got into the tendency of looking at a draft essentially with the purpose of incorporating the law. But the law will come later. The first is your brief outline of facts, which must be precise and concise, drafted in a manner that the contentions will now develop from your factual narrative. When you do your draft, please don't use big words. You have a tendency today to use words which appear in judgments without realizing that those words may or may not apply to your draft. So when you draft the factual matrix of your case, the language should be simple, concise, and precise, setting out exactly what transpired on a particular event or on a particular date. If you bring in big words, you may lose the text on which you're supposed to proceed. In the old days, when we used to receive special leave petitions, grounds used to be one-liners. Today, one ground runs into 15 pages because we are quoting. Quotations don't matter. What matters is the context in which you are putting in that particular ground. One-liners can be the trial court has erred or the courts below have erred on facts. Because your narration of facts in your grounds point this to the first ground. The findings of the courts below are perverse. Perversity comes because the trial court or the courts below have failed to notice contentions of law. They might be per curiam. There might be diverse things which come in when you're looking at a particular draft of perversity. Perversity can be a total misreading of the facts. Perversity can be the ignorance of the judge. So a one-liner, the judgment, impugned judgment is perverse. The impugned judgment is contrary to settled principles of law. Now, these are one-line grounds. They will convey a meaning to a judge of the Supreme Court who's deemed to know the law, that this person who has drafted this petition knows what he's talking about. You frame questions of law. In the facts of the present case, whether the High Court was right in holding this way, whether the High Court erred in exercising its jurisdiction on these facts in this particular manner, those are questions of fact, they're not questions of law. Supposing you have a question arising out of a particular statute. Take, for example, let's take, for example, the Criminal Procedure Code 302. Now, 302 today has become a matter of great debate and discussion with thousands of judgments of the court. How do you read your SLP into that particular law which raises a question of law? That is the art of a draft. If you can master your facts, if you can register the law, interweave the two, that becomes a good draft. Quoting copiously, like the SEC does, we have in the SEC today the judgments which are coming, running into God knows how many pages, quoting and digesting cases and case laws, and eventually the eventual conclusion in the judgment may be in 2 paragraphs. That is not the law. The law is when you look at those judgments which you have quoted, develop a question and move it into the statute with which it relates. The challenge to an advocate is to be precise both on facts and on law. Let me give you an example. I have made a short note just for your references. If you look at an original suit, original suits come into the Supreme Court under Article 131 of the Constitution. Correlated, just give me the Supreme Court rules, please. Correlated to the Supreme Court rules. Now, the Supreme Court rules have a specific provision which deal with suits. I'll just give it to you. Give me Order 25. Give any old rule will do, doesn't matter. Just give it to me. Now, if you see the Supreme Court rules here, you will find a very interesting thing over there which none of you look at. I am now looking at suits. Original suits come within the purview of Part 3 of your rules. It says original suits. The first is parties to a suit. Order 26 says plaints. So now it tells you a plaint shall be presented and all plaints shall be registered and numbered. Every plaint shall comply with those contained in Order 29. Now, plaints shall contain the following particulars. That is Rule 4. The names of the plaintiff and defendant, the facts constituting the cause of action and when it arose, the facts showing that the court has jurisdiction, the declaration of relief which the plaintiff wants. If you look at this, you juxtapose it with Order 7 of the Civil Procedure Code, you will find it to be in paramateria because that is what the plaint is. You go further, The plaint shall be rejected where it does not disclose the cause of action. Order 7, Rule 11. Whether suit appears from the statement to be barred by law. Again, Order 7 principles. So when you draft a plaint for filing in the Supreme Court on behalf of a state or on behalf of the union, you must examine the provisions of Part 3 of the Supreme Court rules, which are Order 25, all the way down to Order 29. Order 29 says, in this order, pleading means plaint or written statement. Every pleading shall contain only, please mark, only a statement in a concise form of the material facts on which the party pleading relies, but not the evidence by which those facts to be proved, nor any argumentative matter, and shall be divided into paragraphs numbered consequently. So if this is a plaint, it's a statement of fact. It's not argumentative. It is not evidentiary. Those are separate matters which come in later. That's your written statement. A written statement says each allegation of fact in the plaint, if not denied specifically or by necessary implication, or not expressly stated to be not admitted in the pleading of the defendant, shall be taken to be admitted. So the written statement again has to be precise. So this is just an introduction to you to what a suit is. Now let's look at the writ jurisdiction of the court, juxtapose it with Order 38 of the Supreme Court rules. If you have the Supreme Court rules, please keep them next to you. It will help you. Just get the Supreme Court rules if you're sitting in. You will get an idea of what the rule says. Now, Order 38, applications for enforcement of fundamental rights. Article 32 of the Constitution of India. Every petition under 32 shall be in writing and be heard by a division bench, etc., etc. Then it says the habeas corpus shall be accompanied by an affidavit. A petition shall be posted before the court on the return day. Likewise, it is now telling you what all you will have to do when you file a writ petition. You've got a habeas corpus, you've got mandamus, prohibition, certiorari, quo warrant to another directions or court orders. So this tells you what it is. The second part of the rule, Rule 12 says, what's a public interest petition? What must it contain? A public interest petition may commence in any of the following matters, suo motu, so on and so forth. Now see sub-rule 2 of 1. In a petition filed under clause D of sub-rule 1, the petitioner shall disclose his name, complete address, email address, phone number, proof regarding personal injury, so on and so forth, the facts constituting the cause of action, the nature of injury caused or likely to be caused in the public, the nature and extent of personal interest, if any of the petitioners. You may have a personal interest. You may be a petitioner in person as an advocate. You can be. So you must disclose why you've come in person. But if you've not come in person, then you must say this. Then it says, details regarding any civil, criminal, or revenue litigation involving the petitioner or any of the petitioners which has or could have a legal nexus. F, whether the concerned government authority was moved for relief sought in the petition, and if so, with what results. This clause F is essentially for the purposes of mandamus, where you say, I demanded justice, but it was denied to me. The court may impose exemplary causes. I'm not concerned with that. But as I said, the Supreme Court rules also turn around and tell you how you should present your cases, what they must concern. Let's come to the next chapter in this very rules, those of you who are holding it. Application for transfer of cases, Order 39. Applications for transfer of criminal proceedings. Later on, you have applications for transfer under 139A. You have the other provisions for transfer under 139A and 25 of the Civil Procedure Code in Order 41. So if you see all these three, you will see what the requirements of a transfer petition are. These are the kind of things you must incorporate in your transfer petition. Civil, criminal, or under Article 139A. 139A says there are 20 petitions pending in different courts. Please consolidate them here or bring them to a single court. What does it say is mentioned in your rules. Then The area which occupies most of our time in the Supreme Court are specialty petitions. The specialty petitions come within the domain of the Supreme Court rules, and they set out what exactly one is supposed to do in dealing with this. You will find Order 21 of the rules which deal with what the specialty petitions are supposed to be and what they're supposed to contain. Let's have a look at it. One is certificate of fitness. I'm not concerned. Now, please come to Rule 3 of Order 21. It's very salient. The petition for seeking special leave to appeal filed before the court under 136 shall be in Form 28, appended to the rules. No separate application for interim relief need be filed. Interim prayer should be incorporated in Form 28. Now, please see Form 28, which is there a part of your. If you see Form 28, it is something which we don't look at and we omit in our drafting pattern. Please see Form 28. It sets out the form. There's a question, do you have the form before you? If you have, otherwise see it later. The form is very specific. There's a list of parties, then there's a salutation, then it sets out the order which you are challenging, and then you frame the questions of law. Then you specify the grounds and the details on which you are to proceed. Simultaneously, you are supposed to give a statement and a concise statement of facts which comes in your list of dates. Your list of dates is not a repetition of a specialty petition as most of us do. We lift everything into the specialty petition, bring it into the list of dates. We forget the relevance of the list of dates by that. List of dates is events which take place leading to the institution of the present petition in the Supreme Court. We go to the next part of it, which are appeals under specific acts. After all, the Supreme Court has powers under various acts. Let's look at Order 23. Oh, I could not go. All right, just one. I'll get it. I'll just get it. I'm told that I'm not clearly audible. Is this better, Bharat?
Yeah, now I can hear. I don't know whether you can hear me.
No, I can hear you. I
Okay.
can hear you. I'm not cut off that badly.
Okay.
Am I audible to everybody now? So we come back. Now we were dealing with appeals. Please come to Order 23. Order 23 has to be read in juxtaposition with appeals, the appellate jurisdiction under 132, read with the enlargement of jurisdictions of the court. Now let's see what Order 23 says. Appeals under the Advocates Act. You will find other appellate provisions in the different rules which are there. So the appeals under the Consumer Protection Act come in 24, Order 24. You have other appeals which come in different provisions, and they dilate on what you're supposed to present in an appeal. Then you have the very powerful view which we take that the court is wrong. Damn it all, it's made a big mistake. Let's file a review. Because no one is satisfied with the judgment in the final court. You always feel that the court is wrong. And that's your right. So that comes within the domain of Article 137. 137 is the review power of the court. The process and procedure for the review comes in Order 47, almost akin to the Civil Procedure Code. Let's see what the review power says under 47. Review says the court may review its judgment, but no application for review will be entertained in a civil proceeding, excepting on the ground mentioned in Order 47, Rule 1 of the Civil Procedure Code, and in a criminal procedure, excepting on the ground of an error apparent on the face of the record. You see, criminal jurisdictions for review are limited because the Criminal Procedure Code says you cannot upturn a judgment once pronounced. But if there is an error on the record, you can rectify it. That power is only with the Supreme Court, not to any other court under the provisions of the Criminal Procedure Code. There's a salutary reason. If a person is acquitted, by way of a review, you cannot seek his conviction. If he is convicted, you cannot set aside the conviction by way of a review, but you can set it aside in appeal. So the powers of a court under the criminal jurisdiction are very much limited. Let us see what the review further says. An application for review shall be by a petition filed within 30 days from the date of judgment. It shall set out clearly the grounds for review. You don't set out the facts. Where the error is, you will pinpoint. You will not write 50 pages in a review petition. You will write 3 pages to show where the court has gone wrong in your opinion, wanting a review of the order. Now, let's travel further. You have the enlargement of the jurisdictions of the court. Trial court convicts, High Court acquits. Trial court acquits, High Court convicts. Read with the enlargement of jurisdiction of the Supreme Court. So that power comes under the provisions of Article 138. 138 deals with the enlargement of jurisdiction of the court. Your petitions come within that domain. Then we come down to the auxiliary or ancillary powers and the plenary powers under 142. 141 says the judgment of the court is binding. 142 says it may do justice. Now, read this with the power of the president to consult the court under 143, what we call the reference. References to the court are dealt with in Order 42 and 43. So when you see the reference powers under Order 42 and 43, you will realize how tacit and clear our rules are for these purposes. I'm sorry, did I say 42? Yes, 44. Order 43 and Order 44. 43 says reference made by the president. And in the reference, the court shall devise its own procedure because the reference has been made by the president. He will frame the questions on which he seeks an answer. You have nothing to do with it. But simultaneously, references are made by the central government or by statutory tribunals under Order 44. Again, the advocate and record has nothing to do there, excepting notice is issued and you want to file a reply. So references are a totally different kettle. They come pre-drafted by the constitutional authority wanting an answer. I have given you a brief gen of what the powers are, where you come in as advocates and record, and how you have to function. If you have seen the jurisdiction of the court, let us now come to the essence of drafting. I began by saying the essence of drafting is a grasp of facts and the learning of the law, which goes hand in glove. If you are drafting a petition and you don't know how to put it in which under which statute, you have done your client a total disfavor, because you are presenting facts without knowing the statute with which you are dealing. You're drafting a petition. There was a joke which we had once upon a time in our system which took place. The young advocate is told by his senior, there's an execution petition, would you go and draft a specialty petition for me? So this guy looks at Criminal Procedure Code, his execution is meant for hanging, sir.
Where do I draft a petition for that? That's an appeal. So the senior says you are a daft dolt. Look at the civil procedure and order 21. That is also execution. Criminal procedures, executions are different, civil are different. So we have got to be clear as to which provision we are proceeding under, which are the statutory provisions we are looking at, constitutional provisions in the case of an appeal, constitutional proceedings in the case of drafting a writ petition. Constitution is wide, very wide. Article Part 3, directive principles which you seek enforcement of without saying the particular provisions, constitutional powers, money bills, functioning of the legislature in framing an act, the 3 lists under the 7th schedule, Articles 246, Article 254. So the whole scope is very wide, and it is here that your knowledge of law is tested when you draft your petitions. My earnest request to all my fellow colleagues at the bar who profess to become advocates in record, do not follow the routine, become different. You become different by the process of learning, not by the process of copying. Cut paste is not an answer. Knowledge which you expound into your drafts becomes the fundamental of a good advocate. The grading takes place there. So to sum up, you have questions which are set for you. Somewhere we give you the opportunity of seeing the statutory provisions. Many a times we don't, and this time we will not. Moment we mention statutory powers, we deprive you of the privilege of using your intelligence to know the law and develop it. Your drafting should be based on the facts presented to you, presented correctly in the sequence as prescribed by the Supreme Court rules, and juxtaposed with your intelligence to make the draft sound that it is done by an intelligent advocate who is trying to do his best for his client and in turn work in the betterment of the system. That is my short discourse which I wanted to have with all of you on the principles of drafting, which should be followed in the court. I now leave it to Bharat.
Am I audible now?
Yes, loud and clear.
Okay. Kailash has already talked to you about what I would call the steel framework of drafting. And I will now get down to the nuts and bolts, which is absolutely no point in repeating what Kailash has already said. You must remember one thing, that whatever be the draft, leave aside specially petitions which have a formulated framework in which you have to draft, which has been set down by the Supreme Court in the Supreme Court rules. That's a draft which is different in nature. But all other drafts, you have to start with the basic premises that you have a title of the case, then you have the provision of the Constitution read with the rules of the Supreme Court rules as to under which provision what draft is being made. Then the first paragraph of the draft of the petition should say why you are filing it. Whatever be the draft, whether a transfer petition, a writ petition, or a review petition, whatever it is, you must always say why you are drafting in one paragraph. Then you must introduce the parties. It must be made very clear as to which are the parties, who is the petitioner, who are the respondents, and that will clarify in your mind also as to who is going to be responsible for the acts or the omissions which you want to present to the court. Then you must come down to the next lot of paragraphs are the specifics. For example, you must, if it is a appeal, if it's not an original petition in the Supreme Court like a writ petition, then you must say as to whether all the documents which were in the lower court, all the pleadings, etc., have been taken on record, and whether you have gone beyond it. Because if you want to put in any other additional facts or legal principles, or even some prayers which were not before the courts below, then you have to file specific applications for that. Then you must say the facts of the case. You must put down the facts of the case. What is the case, and then come to the legal issues as to what is involved, why you are entitled to do something, why are you entitled to pray for something, and get the relief, and then the relief. Now, let us take up one by one the special leave petition, then the writ petition, the transfer petition, and their various applications. As far as the special leave petition is concerned, there is a formula which has to be followed in the drafting. You need a synopsis, you need a list of dates, you need an integral part of the case, the main SLP, where you need your questions of law, your grounds, your statutory requirements of paragraphs, where you have to, which is required by the Supreme Court rules regarding what documents are being filed, whether you have taken additional ground, whether there is a certificate at the end of the, all this has to be put on record. You also have to remember that unless the question in the question paper specifically lays down that you can leave the list of dates, you can leave the affidavit, you can leave the synopsis, if all that is mentioned, otherwise, please start with the first page, the synopsis, and then go on till the certificate and the affidavit. Now, there is one thing is in the synopsis, in any, whether you file a writ petition or you file a special leave petition, the synopsis consists of a very short enunciation of what is your dispute and why you have come to file it. That is very important. If you don't do that, please remember, as a practical aspect, the Supreme Court judges normally would start by reading your synopsis and reading the impugned judgment, and then they go on to the rest of the paragraphs. Now, it is not that your synopsis should be your SLP itself. I have seen synopsis which run to 40 pages, which doesn't make sense, because then you are putting the entire SLP into the synopsis or the entire writ petition into the synopsis. It should be very concise, not more than 6 to 7 paragraphs, to show that what is the factual problem, what is the legal problem, and why you feel that the order of the court below or order of the authority which you are challenging is incorrect. That's all. Your list of dates, like Brother Kailash said very clearly, it should not be. I have seen people into the habit of putting their legal arguments also into the list of dates. It must be very small, very short. This is the date, this is what has happened. This is the date, this is what has happened, this document is annexed. That's all. And that is why Supreme Court informally tells you that you cannot have a list of dates plus synopsis of more than 13 pages. So you have to juggle your amount. But there is,
Bharat, you just tell them how Bharucha and Rumapal, T.S. J.S. Anand and all used to throw petitions out when the list of dates were long. This is
correct.
Not, just throw them out.
No, correct, absolutely correct. In fact,
no, you mention it. I didn't want to mention this. You just mentioned these facts as to how we have to deal with them.
If you mention any date during the course of arguments and it is not mentioned in your list of dates, or the relevant document is not mentioned, they will say you are trying to either conceal the thing or you are not taken enough. You have not taken enough care to draft it properly. Not only this, sometimes you do one thing. When I say that you must identify the parties, please remember, when you have an impugned judgment, the judicial officer can't be made a party. However, there may be cases where a judicial officer in his individual capacity has done something, and that's why he's made a party. I remember one case which was dismissed in Supreme Court only because the district judge was made a party. The registry took an objection, says you can't make him a party because he's a judicial officer. The clerk of the concerned advocate and record said, all right, delete it, without realizing that the act which had been challenged in the courts below was of the district judge in his personal capacity. He had occupied illegally a property. And that is why Justice Bharucha threw the brief out. He said you have not even made the person party who is responsible. So please remember, your parties must be very clear. Now, if you know of a judgment or the court has laid down certain provision, certain pronouncement on an issue which is before the court, please do not be afraid if their judgment is against you. Because always have this view, keep it in your back of your mind. If the judgment is against you, then obviously the judgment is wrong. So do not be afraid. Point out why you think the judgment is not correct, why you think it should be reconsidered, why it should be reconsidered by a larger bench. You may succeed or you may not succeed. But this must be put forward. This is the viewpoint. And this must be put before the court. And you may succeed. After all, every reference from 2 judge to 3 judge to 5 judge to 7 judge is made on this basis only, that the lawyers are able to convince in their drafting and in the arguments, convince the bench that no, what has been decided in the Supreme Court is not correct. It has to be relooked at. And there are judgments there are cases which are pending to be listed before 9 judges. For example, the definition of industry, that is pending before 9 judges. So somebody went through the whole exercise. Now, in a writ petition also, you must be very clear, right? When you file a writ petition in the Supreme Court, the only option is you're filing it under Article 32. Article 226 does not come into the picture. Now, Article 32 deals with fundamental duties, fundamental rights. You must be very clear and very specific in your drafting that what you are claiming under writ petition arises out of a contravention or a mistake which is made by the authorities or by the parties concerned, and your fundamental right is heard. You must be clear in your paragraphs, initial paragraphs, to explain how this act or this omission is contrary to your fundamental right protected by the Constitution. No amount of fudging will help you. You must be very clear, because this is the first thing the judges will ask you. So your draft must be such that it is capable of going over this bump. It must be very clear that this is the fundamental right, this is the action or the omission which has been taken, and that is why my fundamental right has been infringed. In a transfer petition, there are 2 types of transfers to Supreme Court. One, that there are similar petitions pending in various courts, high courts or even lower court, and therefore, instead of having a conflicting decision by every high court or every lower court, it's better to bring all the matters to Supreme Court so that one set of one decision can govern everybody. But then when you do draft a transfer petition under this provision, you must state very clearly that what is the issue, how is the issue similar to in the various courts, and my personal suggestion would be that if possible, you must say that the question which arises in each of the petitions which you are citing to show that the same issue is pending before each of the high courts is the same. And therefore, if you are able to, when you are drafting the thing, not for the exam, but generally, when you are drafting, if you are able to get copies of the grounds taken in various courts, in various petitions, you could cite them to show that they are the same. Now, the second set of transfer petition is where you say that this issue is already pending before the Supreme Court, and the Supreme Court is going to decide the issue. I have a similar matter in A, B, C High Court, and if it will be better that I am also allowed to get my petition transferred to Supreme Court, so that the issue is A, not decided without hearing me, and B, that my case is also governed by that. And you must point out why, what is the issue pending here, which is the matter, what is the issue in your matter, and why it should be brought. There is a third set also, which is what I call the jurisdictional transfer. And that is that when you want to say for certain reasons like somebody is who is not so well off is staying at a certain place, then you want the matter to be transferred from one high court or from one state to another. The power is only given to Supreme Court to transfer these cases, but these are not transfers to Supreme Court. These are transfers from one state to another. And there the issues are different, the questions are different. But remember, in your facts, you must state each point carefully. Why transfer it from one state to another, or when you want to transfer it to Supreme Court, why it should be transferred. It should be all very clear in your draft. It should never be any no fog in this issue, because otherwise your draft will be thrown out. Now, when you have appeals, the what is called the statutory appeals. In statutory appeals, the provision is always there in the Supreme Court rules and also in the concerned act. Now, please be very careful. When you draft a statutory appeal, please remember, in all cases, certain orders are appealable to Supreme Court, certain orders or decisions of the tribunals and the courts are not appealable. So where, for example, the Armed Forces Tribunal. Now, certain orders of the Armed Forces Tribunal are appealable directly to Supreme Court, but certain cases you can't appeal because it's not appealable, and therefore you have to come in a special petition. So you, as a drafting lawyer, will have to ascertain whether the order which is impugned is it appealable as a direct appeal or it is not. And I'll give you another example. For example, in the case of National Consumer Commission, Dispute Redressal Commission, if it's a final order in a original petition before it, an original complaint before the National Commission, then an appeal directly lies to Supreme Court. But in case the order arises out of a revision or an appeal, then there is no appeal to the Supreme Court, then you have to file a special petition. So, merely because there is a provision in the concerned act that a certain type of orders are appealable is not sufficient to file an appeal, statutory appeal against all orders. You have to be very careful and check whether that is an appealable order or you have to come in specially petition. Now there is a question of review petition. In the review petition, as my friend Kailash Vasudev said, you have to show that A, there is an error in the order impugned, B, that it's an order apparent on the face of it, not merely a difference of opinion between yourself as a lawyer and the bench. You are the bench decision is binding on you. You can't say I don't agree. That's not a. It should be apparent on the reading without a convoluted argument. At least in the draft, you must put forward in such a manner that the impugned order has to be reviewed because of the following errors and point out the errors. And these errors must be A, not factual. These errors must be legal errors. This must be very clear and it should be clear from reading. One example which I found that is appreciated by the court is that if a provision of law is ignored in passing the original order, now that is a error apparent on the face of it. For example, if there is an amendment to the act and the amendment to the act is ignored by the court, or another example, suppose an amendment is made but it has not been brought into force, it has not been notified by the government, so the amendment is not, it doesn't have a force of law. Now if the Supreme Court has passed an order or a judgment relying on the amendment which has been not notified, then that's an error on the face of it. So you have to very carefully judge whether the and put it down in your draft. Now, one thing which is true for all types of drafts, you must look before you give the exam for this paper, drafting paper. Please sit down very carefully and go through the basic framework of each petition. because there are certain things which are required in separate petition, the type of petition, and certain things which are common to all. You must keep in mind that if you want to score well in this paper, you will have to ensure that every single required thing is not missed. For the example, the certificate in the SLP or the provision of law which you have to state in the beginning of the petition. All this must be done. For example, take another thing. Suppose in an SLP, a person is coming in SLP is a petitioner, but he was not a party in the lower court below. Now you are required to file an application to be given, which is called permission for filing of special leave petition. But now there is a requirement that after first paragraph of the SLP, you must put another paragraph where you state the same thing. So please be very clear that you do all this. You put a tick on each check box which is required.
Mandatory compliances.
Yes. Otherwise, your examiner is going to throw the paper at you and say, "No, sorry, nothing in it. You don't even know what is to be done." This is not a pleading paper. Please remember, this is a drafting paper. So all your I's should be dotted, your T's should be crossed. Be very, very careful. And therefore, before you sit for the exam, please have a very close review of a suitable draft of each petition and each application, so that you are very clear. Supreme Court is very good about one thing, and that is that there is no possible thing for which you can't file an application. Whatever you want the court to do, you can file an application, the court will decide. Nobody is going to stop you. It is not like the court saying, "Oh, this application doesn't lie under that provision or this provision." It is not there. And I have seen certain people, very, very senior advocates, when they were not so senior, they have filed applications of stay, which when we used to have stay applications separately in SLP, and on the top of it they put the stay application under a provision which is analogous to section 151 of the CPC. And this is filed with the SLP. The registry called the AOR and said, "Please explain what is this. We can't understand this." So please be very clear. Keep in mind what are the provisions which have to be put forward. Put it very clearly. See the format. And I've noticed in some of the earlier exams which are held that people forget that synopsis come first. They tend to put it wherever they remember that their synopsis has to be put. So they'll put it in the middle of the draft or anywhere they feel like. Don't do that. This shows your carelessness. And in drafting, carelessness is as bad for your case as an actual error. Because you must remember, the judges get 60 to 65 cases to read every day. At least in the miscellaneous days. They will lose their temper if they find such sort of carelessness, etc. So when you sit for the exam, your draft must be as if you are filing it, placing it before the court. Don't treat, of course, it will be shorter. And as Kailash said, you should have used your own brain to use what provisions of law to use, what provisions of Supreme Court rules to use, which provisions of the Constitution to use for a certain question, to a certain draft. You should not be asked, you shouldn't be provided all this. This is you are, after all, sitting after 4 years of practice in Supreme Court. So you must know all this. Keep in mind, it's not very tough. There are not too many provisions. It is not like ethics paper which you used to have earlier, where you end up by having tons and tons and tons of clauses and duties and etc. to remember. This is not like that. It is simple. Please keep it in mind. And for heaven's sake, read the paper before you give the answer. I've seen people look at the question and answer something which is not asked. I'll give you an example which a lot of people may not like. Last year, the first question of the drafting paper had findings of the trial court, findings of the high court, which all agreed, excepting for one finding of the high court, about which SLP had to file. at least half the papers which I got to examine, they had answered they had raised issues about every question excepting the one which had to be asked, which obviously meant that they had not read the paper carefully. Read the story, no problem. Read the novel which is written in the question, but please also read what they want. What is the issue? That is how, if you write a draft which skips the main question and goes into all sorts of things, it doesn't help. You may write 10 pages, but you miss the main point. If, for example, now with the COVID, one question which is very frequently asked in any draft, please give a reason why you would want a petition to be transferred from A to B. When there is a virtual process available for attending the hearing, why don't you do it? The answer is that 50% of the people miss that question part. They gave the entire transfer petition, but they missed this part that you have to answer. Because remember, if this power or the right to attend by virtual means is available, then the one main reason for transfer of a case from A state to B state goes, because you can do it virtually. So you have to give a reason why. So these are sort of things which are going to have problems with. And I am not going to repeat all the rules and all. Kailash has done it all well. I am only saying, please be very careful. For heaven's sake, read the paper. And also when you remember that you must give all the required aspects of a petition which are required, because otherwise your petition as drafted in the paper should be such that the registry should have difficulty in finding objections to it. That will give you a good draft. You are not supposed to write a 50-page draft for every question. But whatever you write should follow the sequence, follow the requirements, follow what is required mandatorily by the registry. And like I said, provision under which you are filing it, identification of the parties, what you are trying to achieve, what are the facts, and what is it. Accepting SLP, if you follow this procedure in every petition, you will succeed in your. Now, remember one thing. After the review petition, the Supreme Court has now started curative. Now, in the curative, there is a requirement for filing a curative petition that it should be countersigned by a senior advocate to show that he thinks it is suitable to be a curative petition. When you are drafting a curative petition, you obviously can't give an okay by the senior advocate, but you must write down one line that yes, this has to be okayed by a senior advocate. Put that requirement, mention it. One trick which you can use, which long time back when I gave it 86 my AOR exam, I tried, is that when you are running out of time and you have to put in an affidavit or put in a synopsis and you don't have time or put something, then mention at the end of the question, scribble down that look, this document is to be also required at this stage. You'll get this right credit for it. The reason is, what we want to know is, are you aware of what is required in the draft? Have you done it properly? That's it. Not that whether you have put in another 2 pages of writing that part. It should be sufficient to understand. So I think that is sufficient. I don't think I need to go any further beyond it. Anybody wants to ask any question, anything, they are welcome. That's it. Thank you very much.
Why should the court, just 1 second, it's gone up now. 1 second, I'll read the exact question to you. So please answer why the court would transfer a matter if it can be heard virtually. The answer, it doesn't transfer.
No. No, the answer is that the person who's requesting for the transfer is A, not capable of using a computer, B doesn't have a computer, or
That's a
C
different-
is in a position that the network is not there. Whatever, you have to give all these reasons. There is no other reason.
The other reasons are standing good, but to say that even if it's not to be on virtual hearing, the inability to access the virtual world.
That is the only answer you can give. And sometimes, for example, when they require evidence, you can always say that giving evidence virtually becomes very difficult. Although in arbitrations they are trying, but it doesn't work. So you can use that also as a ground. That if it is at the stage where evidence is to be required, then the demeanor of the witness, the attitude of the lawyer, all that has to be seen, and it's not sometimes not possible on virtual. So that can also be a ground.
Look, I'm open to more questions because in the initial part of when I was issuing my discourse, the sound was not clear. So
Yeah,
if any of you have any questions for me, I'll be happy to take them.
Can you throw light on?
No, as I said, when in the initial
Somebody is asking a question. Somebody is asking a question. What is it?
formulation of prayer, can you throw light on?
Question of
Just
law.
1 second, where is it gone?
You have to write synopsis and affidavit. It asked only.
No.
No.
It's not. It's not a question of giving a synopsis and affidavit only if asked. It's the other way. Nowadays, in the question, they always say, don't forget about the affidavit, forget about this. But if they don't stop you, then you have to give synopsis. Assume that you have to give everything, excepting what is in the I think last year, affidavits were not required. List of dates was not required in some of the
questions.
So therefore, that you can leave then. List of dates is really not material so much in a drafting paper, in the sense that it is material because you have to give the facts. If we are out of time and remaining is only an affidavit. Yes, I said that you can.
Then the prayer.
Yes. You can mention in one line that affidavit has to be filed along with it, which will be of the similar nature as mentioned, as given with the other questions.
Have to draft affidavit and certificate in all the
No,
questions.
same questions.
There's one simplicity dismissal of an SLP. What ground should be taken in a review? Well, look at Kunia Ahmed's judgment, State of Kerala, that will answer it for you.
Yes. And the format of prayers is in SLP, the prayer is very straightforward.
Ground
So
specialist opinion.
it's that specially be granted to file this petition, etc. But what is more important is the interim order, interim prayer. When you ask for stay of an order, then you have to say the stay of the operative order. Please don't ask a straight stay of the High Court order, whereas the original relief is granted by the trial court is the one with the issue, because the stay of High Court order will not really make any difference. So be very careful.
What relief you are seeking should be specific.
Yes. And what is the grounds? What grounds?
Can we plead fundamental laws in a court? You have to if the question arises. Can we plead fundamental grounds? Yes, of course you have to plead them if they are there.
नीचे ये क्या है इसे ground please that whether
Set out the grounds or fact also.
no, if the question says you please set out the grounds, then obviously only the grounds are to be set out. A question of law. Now see, please understand, that is a very, very difficult
Task for drafting.
setting out a question of law, because what happens is that in a question of law, you have to actually state what is the legal issue involved. You can't say that the High Court has erred in these facts. So, in fact, I remember there was one certain advocate from Bihar. He's now gone back there. He used to have 3 questions of law and 4 grounds, and then finished the SLP. And his SLPs were always heard by the court. The reason was he stuck to the main issue. That this is the legal issue, this is what. So questions of law have to be confined only to the legal issue which is raised. And if you don't have a legal issue, then SLPs really don't stand. You must, I would say, create appropriate question of law. If you want to mention a question, a case, if you remember the citation is good. If you don't remember the citation, at least mention it by the name, that in the case of so and so, this is what happened. In a writ petition, although question of law as such is not to be framed, like in a second appeal or in a SLP, but even then in a writ petition, you must give what is the legal issue involved.
And why the jurisdiction?
Yeah, otherwise the 226 or 32 will not lie. So we can't provide sample drafts. That you have to arrange for yourself.
What is the good tip for scoring? Don't know the examiner.
See, there are two in the SLP. There are two very essential paragraphs. One says that the documents which are being filed formed I think Rule 3 and Rule 4
Constituted a part of the trial court record.
Yeah, that is a part of the lower court documents, lower court below. And see, for example, delay, you have to file a continuation of delay. For translations, if you have got a document in vernacular, you have to file an application for permission to file translations of documents.
Just Bharat, 1 second.
Yeah.
When you ask for exemption from translation, please don't say it is an official translation. You must say it is a true translation.
Yeah, it's a true translation and done by the advocate or somebody.
That's right.
Don't official. Earlier it used to be application for exemption from appointment of official translator. Now it is that permission to file the translation. You don't have to do that. But in fact, if your list of dates and synopsis together are more than 13 pages, then you must also file an application for permission to file a lengthy list of dates or lengthy synopsis. That must be done. And if you have got a matter from Bombay High Court, then you are in serious trouble. Their synopsis is bigger than their petition.
SLP. It has happened.
Yes, yes.
Lot of judges.
They go to triple X and triple Y and
yes.
It's ABCD.
As from ABCD.
Yeah.
And but judges haven't considered them. They just rejected the especially on that ground alone.
True. As far as counter affidavits and reply are concerned, firstly, you must decide whether you have any preliminary submissions. If that is there, you must mention the preliminary submissions. Otherwise, the necessary mandatory paragraphs are what is stated was part of the record below. Nothing additional has been given. Every content of every paragraph of the SLP, whatever you're filing the counter to, is denied unless specifically admitted herein below. Then
that is the pleadings. The rules of pleadings are specific.
Yeah, but remember one thing. Whenever you file any affidavit, whether it is affidavit in support of a petition or a counter affidavit or reply affidavit, you must point out that if it is an individual, then it is fine. If it is a respondent or, but if it is a incorporated body, a registered society, a corporation, a
legal person,
then you must point out who is doing it and how is authorized and what is the document which authorizes him, and that document needs to be put on record that it is being filed with the wakalat number. You must do it.
Authority to file.
Otherwise, your petition is no meaning. Your affidavit is meaningless. And always mention, if any document is annexed in the affidavit, always mention this is a true copy of his respective originals. You must put that. What else?
There's no extra para needed.
Need not be. Well, you can mention the case law in synopsis, not in list. List of dates should be bare bone list of dates. You may have 20 things to say about a document. Don't say in list of dates. That has to go to SLP. Grounds. it should be like a fossil skeleton. Only the bare bones and nothing more than that in the list of dates. In grounds also, see, case law is, it's not a question of mentioning a case law in question of law or in list of days or in grounds. The point is, what are you using the case law for? If you are drafting and saying A, B, C has happened, and the conclusion should be this, and the High Court has taken it wrong, then you can say as held by Supreme Court, as held by this. But if you say that, then it is, you can mention it in the grounds also, there is no problem. Or you can mention the question of law. It's no issue that you can't do it. But the point is not merely for saying, I have a writ petition from the High Court where he has cited 23 cases. None of them are relevant to the main issue. So don't cite cases just for the sake of citing.
Sir, apart from application CIPA file, what is the, you need not cite cases the way you are asking.
No.
No, he's a gentleman here is asking.
Somebody is asking
Case.
for reproduction of.
It's not a very good way of drafting.
No. See, the point is, you have a legal issue. For example, let's take an example. There is a judgment of the Supreme Court on point A. Now you are agitating before the Supreme Court that this point has been wrongly decided by the High Court. They did not take this view. They took a contrary view. And this is the view which has been upheld by the Supreme Court, and therefore High Court should have gone there. Fine. You can cite it, the latest judgment. But not for the sake of citing. And you really do, unless your case is totally covered by a paragraph in the cited judgment, there's no point in quoting it, because all judges get SCC free at home, so they can get the
from the computers.
They can get it. They are intelligent. No, we have taken a decision. I think we should not mention what provision of law is to be there in the question. You have to be, after 4 years of practice in Supreme Court, you should be aware of what question, what provision will be applicable in a certain set or certain set of relief. For example, if you are an SLP, obviously you should know what is the IBC code provision which is not been read properly, understood properly, or whatever provision, whatever, consumer code, whatever. You have to look at it very carefully. Drafting bail prayer in SLP, please.
Drafting bail prayer has got 4 fundamental principles of bail. Put them in. What is the problem in that one? It's always a 4 test.
In the bail, you have to look at why bail should be given. There are fundamental
the 4 fundamental principles on which bail are considered.
In what conditions bail should be given? Put them if they are there. Suppose you are coming against the grant of bail, then you have to mention why the bail should not have been granted.
Cancelled. Yeah.
If you are coming for cancellation of bail, then cancellation of bail and not an appeal against grant of bail are 2 different issues. So you must be very careful about it, what you are doing. And normally, if you have a good case, you have a good case to get bail. If you don't have a good case, you will not get bail. So bail applications are very straightforward. You have to say why the bail should be granted. I don't think there's any major issue about it.
How many questions in total and pattern of choice? That the judges committee decides, we don't.
Now, as far as the PILs are concerned, the only difference in a PIL and a normal writ petition is that in a public interest litigation, this label applies only to a writ petition where the petitioner doesn't have an immediate and personal interest in the case.
That's mentioned in the rules, Bharat.
I know, but the question has been raised by somebody. What I'm saying is you you have to justify. Either it should be of the interest to the entire public, or because a petition in representative capacity and a petition in the PIL are two different things. So PIL means that it should be of interest to public at large. Something which needs to be heard. Now frankly, there is nothing in the constitution or nothing in the laws which says the PIL can be heard. Normally your locus standi issue principle comes in clash with the PIL. But you must remember the Supreme Court in India also does something which most of the courts in the world don't do. And that is that Supreme Court in its capacity as the final court is also an instrument of change. So from Justice P.N. Bhagwati's time, they have taken the view that, look, there are certain issues which the person who is directly affected is not able to bring up for financial reasons, for physical reasons, for social reasons. And therefore, people who are not directly affected should be allowed to put it forward and place it. Now, it is totally up to the court. It may take 10 PILs in a day and may decide that 9 of them are worthless. And the Supreme Court has gone to the extent of levying very heavy costs when they think that somebody has done something
Wasting time.
I would say silly. And I'll give you a good example. The petition which was heard 2-3 days back regarding doubling the number of judges in the court, that was dismissed only on the ground that that is A, there's not part of the court, and B, that will not remove the problem, which is the reason. Also be very clear when you file a PIL or you draft a PIL that what relief you are suggesting or what prayer you want to be granted should be directly connected to the problem at hand.
Yes.
It should not be something remote. And
Chalo,
that is
Bharat.
the only thing which I think PIL you need to be careful of. देखो और कोई क्वेश्चन है तो आंसर कर दें देखो.
Nothing much coming up now.
Don't think so. SLP TP review with original suit. ये क्या है?
What is the ideal number of grounds and questions? There is no ideal number. Hello?
There is no ideal number of grounds and questions of law. You have to decide what the facts of your case are. And
Maybe 3 grounds are enough, maybe 30 grounds are enough, depends.
No, I have told you I've seen petitions with 6 grounds and they have been heard and allowed by the court. The point is, the judges must be able to appreciate what the flaw of the lower court's case is, the judgment is. It may be the first ground. Earlier, there used to be a problem that when you raise a ground, the judges sometimes used to ask, have you taken this ground? Now it's not so often, but they still can ask you, did you take this ground below?
Yes.
If you have not, go and file a review.
They are doing that now very often.
So that is not so. You can't give a figure.
Security features.
Writ petition doesn't need a question of.
No, you can draft the certificate in the curative, which is to be given by the senior, but you mentioned below it that it has to be signed by a senior, not by the
What
AOR.
should come in?
No, both require certificates. Bharat, in curative, both have to give certificates, AOR and senior.
One certificate is of the AOR.
हाँ.
He's talking senior
Senior तो mandatory है वो.
Mandatory, but you can mention that this certificate, this teacher has to be given. Obviously, you can't draft it because the senior has to do it.
Yeah.
What questions don't need any?
You don't have to write Form 28. You have to use the format.
Against an interim order of the NCRDC, well, again, there are some, I think under the Consumer Protection Act, one or some type of orders can be challenged, but mostly it will be SLP.
It has to be 227 jurisdiction.
That is the provision of appeal.
No, 227 jurisdiction in this has been watered down.
Yeah.
Chalo, let's take leave.
Right, sir.
You can catch hold of us in the corridors whenever you want. We are available
Yes.
for
And
any of your questions.
you will need log on to catch hold of me.
Thank you. Thank you. Right. Thank you very much for being with us. Been
Yeah.
a pleasure to be with all of you.
Thank you. I
Good
hope
night
it-
and the very best.
Okay, right, Kailash. See you.
Good night. Good night, Bharat.